time is 10 a.m. based on my laptop here. So it's 10 a.m. On 6/30, 2021. And at this time, I'll turn this over to Ms. Delia for roll call.
Thank you. Good morning, everyone. Mr. Dolores Campion,
Present.
Mr. Jerry Bittner,
Present.
Ms. Suzanne Smith,
Present.
Ms. Flor Lujan, absent. Mr. David Morris,
Present.
Mr. Dave Yelovic is absent, and Mr. James Graves.
Here.
We have a quorum.
Thank you. Thank you. And so, look, at this time, I want to welcome one of the newest members to our board. Thank you for participating in doing this for us. At this time, Mr. James, I see here parentheses Jimmy Graves Jr. And so I'm not sure whether you want to go by James or Jimmy, but if you want to say a word or two, here's the opportunity.
Well, Jimmy is fine. James is my real name, but everybody calls me Jimmy. And a few other four-letter words, but we won't go into that. Yeah, like I say, I've been a contractor for at least 50 years now. I've been designing and installing air conditioning systems during that time. I went to Texas A&M University. I got my degree in mechanical engineering, and so I've kind of always been interested in the advisory board, mainly because, and I talked to Bill about this yesterday, but we used to have one in Houston, and I guess they didn't like to hear what the contractors had to say, so they disbanded it. Now the city just kind of does whatever they want to do. So anyway, I kind of wanted to be in a position where, maybe we could rectify some of that. So with that said, anybody got any questions of me?
No, thank you for participating. Thank you for joining our team. And so we look forward to a lot of engagement from all our contractors in the field. And so, yeah, they have a few names for me myself. My given name is Dolores, and my nickname is Dolores. So with that, and a few other choice words as well. So at this point in time, I will recognize Mr. Doug Jennings because we have some Open Meetings Act and some public information that we have to go through. And also, if you would put your phones on mute, and I know that the WebEx can be a little difficult. So if we start, getting some interference, I think turning off the video would be probably the most appropriate. But I'm not sure. I think all our board members need to be on camera. Is that correct? At all times?
That is correct.
Okay.
That is correct.
And so with that said, if the board members could, turn on their cameras, I think we all need to be on our cameras, and that's a little housekeeping rule. So we hadn't had a meeting in a little while, so make sure that all the members here, and thank the TDLR and thank all the staff members for putting this together, because we get to sit here and all the behind the scenes stuff gets done. And so we get to just turn on this camera and hit the mute button, and we can go about our business. So appreciate everybody behind the scenes. And with that said, Mr. Jennings.
Thank you, Mr. Campion, and welcome to all the board members and to our new member, Mr. Graves. It's a pleasure working with you, and our existing members, and I look forward to working with you, Mr. Graves. We did this back in, I believe, October, but we'll do the training again a little bit as a refresher, and because we have a new member on the board. A little refresher never hurts, and we'll hit some of the high points of the Open Meetings Act, the Administrative Procedure Act, and the Public Information Act. Those are the three sets of laws that you just really need to be keyed in on while performing your duties as an advisory board member. The meat of this presentation will discuss the Open Meetings Act. I guess I should have said that differently. We'll talk through the nuts and bolts. The purpose of the Open Meetings Act is to ensure open and transparent government. You will see that theme throughout this presentation, transparency being key. The Open Meetings Act requires meetings of governmental bodies, such as yourself, to be open to the public, and to be preceded by public notice of the time, place, and subject matter of the meeting. We will need to discuss a few key terms so you can understand how the Open Meetings Act works. The first, I think the most basic term is a quorum. A quorum is simply the majority of the members of the advisory board or committee. As you know, the statute creates the advisory board of 9 members. There's an additional member. We just discussed this briefly off camera. There's an additional member, an ex officio, or a member of TDLR staff that is a member. So we have 10 members on this board. So 6 is the quorum for this board. A quorum of a governmental body must be present in order to take official action. In the event that we have a meeting and we don't have a quorum, we can meet, we can have discussions, but we can't take official action. The second key concept is deliberation, and you can just also say discussion. And that simply means a verbal or written exchange involving a quorum of the governmental body concerning an issue within the jurisdiction of a governmental body. So I always like to use an example of, if we were to talk about going to Dolores's after party, that's not deliberation. If we're talking about adopting a rule within the ACR program, that's deliberation. Also, I hope I didn't burden your schedule too much, Dolores. Let's see. So a meeting is a key term, and a meeting occurs anytime in any place a quorum of a governmental body engages in deliberation regarding public policy over which the governmental body has supervision or control, or anytime the body takes formal action. So I like to stress the anytime and anywhere portions of this section. We say earlier that there has to be public notice of a meeting. A meeting can occur in a boardroom after a publicly scheduled meeting. It can occur in the hallway. It can occur online. And so we'll talk how to avoid some of those pitfalls. As I mentioned, the Act requires advance written notice of the date, time, place, and subject of each meeting held. And we provide this notice, TDLR provides this notice in the form of an agenda. That agenda must be filed with the Texas Secretary of State at least 7 days before our meeting. And one of the things we'll touch on later, of course, is a board or committee may not engage in discussions about a subject that is not included on the agenda. Having just stressed that a meeting can happen anywhere a quorum involves in deliberation, what about functions, social functions, and conventions and workshops? So if a meeting occurs whenever a quorum engages in discussion about public business, is there ever a scenario in which a quorum of members of your board can meet in an informal setting without violating the Open Meetings Act? And the answer is yes. If you're at a workshop or a social function, and a quorum happens to be present, feel free to engage in conversation that's incidental to the event. However, the gathering will be subject to the Open Meetings Act if the quorum involves in discussion about board business. So just if you notice that a quorum of members is present, keep the discussion outside of board business. Find something else to talk about. Hone your social skills. Don't talk about air conditioning and refrigeration policy. And that will be very easy to avoid an open meetings violation. So just some key points to remember about the Open Meetings Act. Just always be aware of any situation occurring outside a properly noticed meeting, like the one we're in now, in which a quorum of members is present. Don't engage in discussions relating to board business when a quorum is present and you're outside of an officially noticed and scheduled meeting. And one thing that I've added to this presentation recently is keep in mind that violations don't just happen in physical space; they can also happen on social media. For example, and I'll touch on some nuance later, but just imagine yourself posting a story, a news item on Facebook, and you happen to be friends with a number of other board members, and they all comment on that story. All of a sudden, you've got an open meetings violation because that. You're engaging in discussion about board business on that post. So just keep in mind that violations can happen that way also, and beware the walking quorum. A walking quorum, pretty simple concept. It occurs when a small number of members, less than a quorum, they engage in discussion about board business and then communicate those discussions to other members. So I'll give you an example. Let's just say we have a 5-member advisory board, 2 members, now that's less than a quorum because a quorum would be 3, exchange phone calls and emails expressing their thoughts on an upcoming rule change. Then one of those board members forwards that exchange to another member. So what we have in effect is 3 people of the 5. So a quorum of members have engaged in that discussion outside of regular channels, outside of a regularly scheduled and publicly noticed meeting. So that's how a walking quorum can turn into an open meetings violation. Walking quorums can also occur on social media. I used a Facebook example a minute ago. I'm not really proficient in Twitter, but I know the basic mechanics of how it works. And so I've identified a potential pitfall here. So let's just take an example where Chairman Doe of the advisory board tweets out a link to an online news article about a big issue facing the industry. Another board member, Smith, sees that link and then retweets or shares it, and includes with that share a comment stating it's vital that the board take up consideration of this matter. Another member, Jones, then comments on Smith's post stating we really need to look at Rule 101. Board member Williams comments on Smith's post and says, I agree, let's get this done. And then board member Johnson, thinking he or she might be clever by avoiding using words, posts a thumbs up. What we've had is Chairman Doe probably intended that link go out without involving a quorum of the board. However, we see that 4 more members of the board have engaged in that discussion, and therefore we have an open meetings violation. So just use common sense, be wary whenever you're confronted with a situation in social media where a quorum of members could participate in a discussion about board business, and you'll be fine. Best practices to avoid quorum issues. Don't meet in small groups to discuss board or committee business and then communicate those discussions to other members. I don't know if everyone on this group has been a member of a work group yet, but every now and then we will ask for the appointment of a work group, and typically those have members, 3 to 4 members. We always ask the members of those work groups to keep their discussions private until we come to a fully noticed meeting. And that way we avoid walking quorum issues. Be careful when you're sending emails to other members. So if you're sending emails or texts to a quorum of members, that's a terrible idea. Don't do it. It's not a good idea even if you address that email to everyone individually. You could still be potentially violating the act. And again, don't create posts on social media where there's a likelihood that a quorum of members will participate in discussions. Or if you see a post by a board member, just be wary about contributing to that discussion. We'll switch gears a little bit, talk about open sessions, which we're in right now. A board or committee is limited to discussing the specific items on the agenda. During the public comment period, which we'll have in a moment, you'll see members of the public will be given an opportunity to speak, and the presiding officer will set reasonable limits on commenters. Typically, that's about 3 minutes to present. One of the notes about public comment is that unless the public comment relates to an item that's already on the agenda, there can't be a real back and forth between the commenter and the board. And so we will typically, Ms. Winston or I will jump in if there are a lot of questions and answers going, and we'll ask the board to limit their back and forth. If a member of the public in public comment raises an issue that the board's interested in, or if a board member wants to bring up a topic that's not on the agenda, we have a section at the end of the meeting to place items on the agenda for next meeting, and that's what we'll do. Just so if someone has a great idea and it's not on the agenda today, sorry, unfortunately that's the way it works, and we can talk about it next time, and we'll have a well-prepared discussion. Talking about penalties and remedies for Open Meetings Act violations. If a board violates the Open Meetings Act, any interested person can go to court and get that action stopped or overturned. And of course, interestingly, hate to get to this part, but members who knowingly circumvent the Open Meetings Act may be subject to a fine of up to $500, confinement in county jail for 1 to 6 months, or both. So It's not just a good idea to avoid Open Meetings Act violations, it's the law. We will move to a quick overview of the Administrative Procedure Act. The purpose of the Administrative Procedure Act, we call it the APA, is to establish standards of uniform practice and procedure for state agencies, provide for public participation and transparency during the rulemaking process, and it governs the contested case process as well. A rule, and we're not just going to talk about the theory today, we'll actually look at one. A rule is a statement made by a state agency that implements or interprets law or policy. You know, I think everyone's aware with Chapter 1302 of the Occupations Code that sets out all the statutory requirements for the air conditioning and refrigeration contractors program. Of course, a statute can never include anything, and that's why rules exist. And so a rule bridges the gap between statutory requirements and practice. And so we have a whole chapter of rules governing the air conditioning and refrigeration program, which I'm sure you're all deeply familiar with. There are a number of sources for rulemaking. Perhaps the most common are legislative changes. When a change is made to a statute, our rules often need to be changed. Advisory board work groups often draft or recommend rule changes. Similarly, a discussion amongst the advisory board might generate a rule idea. Staff, TDLR staff might recommend a rule change. Every 4 years, the agency is required to look to analyze the program rules and determine if they are still required, and that generates a number of rule ideas as well. And lastly, there's a creature called the rule petition, and that's just a mechanism wherein a member of the public can request a rule change. And whenever we engage in a rulemaking, this advisory board will have two opportunities to provide input. Today's rule that we'll be looking at in item G of the agenda will be your first blue box here. But this is our flow chart. Typically, we'll have an idea for a rule, which then the attorneys will draft. And there's a lot of behind-the-scenes work done here, talking with staff, submitting proposed rules to the governor's office. And once those hurdles have been cleared, the draft rules will be sent to the advisory board at a meeting for your consideration. So for item G on the agenda, again, this is where we are, first blue box. So if the board approves the rule as written and recommends publication, the proposed rule will be filed with the Texas Register, which is a publication maintained by the Texas Secretary of State. It gives the public access to pending rulemaking so they can provide comment. That will then begin a 30-day comment period on the proposed rule. Once those comments are in, the Office of General Counsel Attorney will review the comments and recommend any rule changes if necessary. We will bring those comments back to you in our second blue box in a second meeting where we will ask your board to review the comments and make a recommendation to the commission. That recommendation might be to adopt the rules as written, or you might see some comments that raise an important point, and you may want to recommend a change to the published rule. Assuming that the advisory board reviews the comments and makes a recommendation to adopt the rules without change, those rules will then go to our commission, the Texas Commission of Licensing and Regulation, which is the department's governing body. So it's a group of seven commissioners. The commissioners will review the rule filing, the comments, and recommend the adoption of the rules. And then that adoption is again filed in the Texas Register, and the rules become effective 20 days after filing. So that's a bit of a lengthy process that all takes place over several months. But again, your board will typically see a rule at least twice. And lastly, we will go into the Public Information Act. You've probably heard this referred to as the Open Records Act. And that act is intended to allow each person information about the affairs of government and the official acts of public officials and employees. And notably, that act makes all documents, records, and other information relating to official business open to the public, with some exceptions. Public information includes any electronic communication maintained on any device if it's in connection with official business. And so one of the things we like to remind you of is that whether our staff is emailing you at a TDLR email address, or emailing you at a personal or company address. If those emails deal with public business, with your role as an advisory board member, which they will the vast majority of the time, those emails are potentially subject to disclosure under the Open Records Act, the Public Information Act. And so you may there may be a moment when you get an email from either TDLR's office of General Counsel or from a member of the public asking for records, asking potentially for your emails or texts relating to your board duties. If GC requests information of you, please respond to us immediately, or at least as soon as possible. And if you get an email from a member of the public or potentially a journalist asking for access to some of your records, please forward that to the Office of General Counsel as soon as possible. And the reason we ask for you to do it as soon as possible is that the Public Information Act puts some pretty strict timelines on us. If we don't respond within 10 days, we may have to disclose an email or other information that normally we might be able to exempt from disclosure. Of course, not everything is going to be public ultimately. If for some reason, let's just say that there's an email communication between staff, between you and staff, and that there's some protected health information in there, that might potentially be exempt from disclosure. Other things like dates of birth, personal email addresses, educational transcripts, and I mentioned health information, we're generally are going to be exempt from disclosure. And that is the end of the presentation. Let's see, I'll stop sharing, and I'm happy to answer any questions anyone might have. Looks like there are none, so I'll hand it back to you, Mr. Campion. Thank you. Mr. Campion, are we ready? I think I'm not seeing any questions. Okay.
Never mind.
Okay, if we have Mary Winston, TDLR, if we don't have any questions from Doug's wonderful training, and I know most of you had this training before, but I know Mr. Grace has not had the training. So if you have any questions now or in the future, just reach out, Mr. Grace, let us know, and we'll give you an update or answer any questions, or we'll have Doug answer any questions that you may have for us. So, okay, thanks so much, Doug.
Thank you, Mr. Jennings. I appreciate the training class. I always catch something different every time we go through this, so appreciate that. So look, I may be having some audio difficulties on my end, so if I don't respond, just somebody give me an ear message or something, and I'll move to it. So we're going to move to item agenda D, approval of the October meeting. So at this point, I need a motion to approve the meetings as written. Do I have a motion?
Jerry Bittner, I make a motion to accept the meeting minutes.
You need a second? Okay, there you go.
I didn't hear. Do we have a second?
Yes, sir, it was David Morris.
All right, Ms. Thiele, will you take roll?
Yes, sir. Doris Campion,
Yes.
Jerry Bittner,
Yes.
Suzanne Smith,
Yes.
David Morris,
Yes.
and James Gray.
Yes.
Motion passes.
All right. Thank you for that. Appreciate it. And so now we move into item E on the public comments. I think we have 2 at this time. And so we'll move on to public comments.
Okay, give us 1 second, Mary Winston here, to get our public commenter back into this room, this virtual room. So Mr. Fickle is working on that, and we'll have that person come in. Okay, I think we have him present. Mr. Glass, do you have audio?
Yes, I do.
Okay, this is Mary Winston with TDLR. It is now your moment, sir, to provide your public comment. You are on the screen in case you can't see it. So we do see you and hear you and welcome you and thank you for being here.
Thank you very much. Yes, good morning. My name is Robert Glass, and I'm the manager of state regulatory affairs for Goodman Manufacturing Company. As of yesterday, 11 of 22 states have either adopted the 2020 NEC or are in the process of adopting the have either deleted, modified, or delayed the implementation of the 210.8F requirements. These include Oregon, Washington, Colorado, Texas, North Dakota, South Dakota, Massachusetts, Iowa, Utah. Yes, I am, and I'm speaking. Okay. I had started. Had you heard any of the first parts, or was do I need to start over?
We did. We heard you.
Did
You
Mr.
stopped
Glass
at
fall off?
Utah.
There you go.
Okay. Okay. Thank you very much. Yeah, and so the last two on that were Georgia and North Carolina. Yesterday, Georgia announced intentions to delete the 210.8F after adopting the 2020 NEC that was effective January of this year. And also yesterday, Colorado announced suspension of these requirements for 1 year. Links to, I've provided links in written comments that I've submitted to the board for your consideration. And so you can check those documents yourself to get the background information. The substantiation used by Massachusetts when they deleted the 210.8F says it best. Quote, the addition of the 2020 NEC has not been substantiated. The loss experience supporting this addition to the NEC was based on an untrained, unqualified work of an air conditioning condenser that ended up energized and thereby caused a boy who jumped a fence and contacted the housing to become electrocuted. GFCI protection saves countless lives and certainly has its place. However, it's a fool's errand to imply to the public that improper work can be rendered essentially safe by waving the GFCI magic wand. For example, contact between two circuit conductors will never trip a GFCI. CMP2 came within 1 vote of rejecting this. Massachusetts needs to set it aside and await proper support, unquote. The HVAC industry has tried to work through NFPA to seek a delay in the implementation of these requirements without success. TIA numbers 1529, 1564, 1589, and 1593 have been submitted to NFPA concerning the requirement. To date, the 1529 and 1564 have been rejected. An appeal has been filed concerning 1564 that will be heard by the NFPA Standards Committee in August. And
Mr.
then
Grimes?
1589, yes, ma'am.
I'm sorry, your time is up. Your 3 minutes are up.
Okay, thank you for your time.
Thank you, sir.
Mr. Fickle, may we have Mr. Tharp next? I do not see Mr. Tharp. Seems like Mr. Tharp disconnected again, so.
Delia, Mr. Tharp has disconnected.
mm.
Okay, Mary Winston, TDLR. Mr. Campion, with your permission, we would like to proceed with the agenda. And if Mr. Tharp is able to reconnect, if possible, can we let you know and we can bring him back in for his public comment?
Hey, team, I'm having some audio on. I
Okay.
don't know if the rest of the team is having the same audio difficulties, but if it's only on my end, just give me a sign. Is everybody having the same kind of audio difficulties that I'm experiencing on this end?
No. Mr. Campion, can you hear us?
Yes, yes, but the situation may be that I may need to log out and log back in. Maybe I'll get a better connection. But for now, if I'm a little lagging on response, just please give me a sign and we'll continue moving forward. So
Okay,
I'm
Mr.
having some
Campion,
audio difficulties on my.
can you hear me? It's Mary Winston. Can you hear me, Mr. Campion?
Yes.
Well, I think you missed it, but our last public commenter was disconnected. So with your permission, we would like to move forward with the agenda. And if he can get back on, can we get him in at that time?
Absolutely.
Awesome. Thank you.
I just got a message, Mary,
All right.
from Michael Fickle and said that Mr. Tharp is on again.
Awesome. We got him back, Mr. Campion. So he'll be
Okay.
able to go now quite
All right.
shortly. Thank you all. Thanks to everyone for your patience.
Mr. Fickle, can you get him on, please?
Can you hear Rusty Tharp?
We can hear you, Mr. Tharp.
Okay, thank you. My name is Rusty Tharp. I work for Goodman Manufacturing. We are owned by Daikin in Japan. And I'm speaking also to support the removal of 210.8F. And I just real quickly like to run through some of the technical reasons why we would suggest that. So as a manufacturer of air conditioners and heat pumps, we get all of our products, as well as all the industry gets our products approved to UL Safety Standard 1995. That's been in use since the early 90s, at least. Ground integrity is actually validated through dielectric voltage withstand test specified in Clause 87. And that particular standard doesn't require a measurement of the leakage currents itself. There is a future standard that is available for use, 2-40, UL 603 through 5-2-40, but compliance with that standard is not required until January of 2024. In that standard, it allows up to 10 milliamps of leakage current. Also, as you're designing air conditioning products, the electronics that go in them also have to meet FCC regulations, as well as component standards such as UL 508C. So those designs are meeting other regulations. Unfortunately, the UL safety standard for GFCI breakers, UL 943, requires a maximum trip current of 6 milliamps. So we have a GFCI breaker that trips at no more than 6 milliamps, and a product safety standard that allows you to go up to 10 milliamps. So there's a conflict between the AC heat pump safety standard leakage current and the GFCI breaker requirements. And because of those incompatibilities, we're not going to be able to presently get products that comply with both standards. So if you don't remove that 210.8F, we'll continue to have the tripping problems in the field. So thank you for the opportunity to speak.
Thank you, sir. We appreciate that. The feedback on that. So I think at this time we can move on to item F, some staff reporting. And look, team, I am having some audio difficulties, so I may need to log out and log back in. What is the protocol for that process?
Mr. Campion, if you have to log off and log back in, even if we didn't have a quorum, it would be okay because there's not a voting item right now. Typically, we would appoint someone to act in your stead as a presiding officer while you're out. If Mr. Bittner would be so gracious to do that. If Mr. Campion,
Yes,
okay,
on my end, I'm
awesome.
catching about every sixth or seventh word.
Okay,
And so I'm gonna go ahead and log off and log back in real quick. So maybe my audio will get better. Now, if everybody's having the same difficulties, then no need for me to log off.
we are not, and Mr. Bittner is going to act in your stead while you're trying to get your audio corrected.
I'm going to go ahead and log off and log back in. Ms. Winston, I only heard like 2 words of that. So let me
Okay.
try this and I will attempt to be right back. Is that okay?
Awesome. Yes.
You get a thumbs up?
Yes. If someone could call Mr. Campion and let him know what's going on and that Mr. Bittner has his back, that'll be fantastic. Mr. Bittner, if you're comfortable handling the show, we can move on with agenda item F1.
Yeah, this is Jerry Bittner. Let's go ahead and move on to item F, staff reports. The briefing on the licensing division and statistics.
Good morning, all. I hope that y'all can hear me okay. Thanks for being here. It's good to see everyone. I'm Lisa Hodek, the licensing manager for the licensing division. I'll try to go slow in case that there are technical difficulties, but my report will be brief. So first, I'd like to say that I do have a new licensing analyst. She started January 15, 21. Her name is Lisa Robertson. She was a head bank teller for over 12 years, and she also was working over 6 years with a shipping and freight company where she handled a lot of customer relations. So she has excellent customer service skills, and she's fitting in really well with my team, and I'm very happy to have her on my team. Currently, I'm also working on hiring 2 more people because I didn't post it here, but because they're not officially hired yet, but that's what I'm working on, and they are replacements of 2 other members of my staff that have moved on within the licensing division for more career opportunities. So I'm happy for them, but sad to see them go. And we will get to our statistics next. So we have here all of fiscal year 20 and the 3rd quarter of fiscal year 2021. The new license is issued. Right now we're at 830. Renewed licenses issued is just over 12,000. We tend to remain at a 99% renewal of online, which is fantastic. It's quicker for the applicants or for the licensees, I'm sorry, to get their licenses because we don't have to touch it. And it allows us to continue to work on the applications. Registered technicians are, sorry, if you'll scroll up just a little bit, please. Thank you. Registered technicians, our total population we're almost to 28,000. So that one is continuing to climb. Again, we have a high percentage of renewals online. That license type can also apply online. And then the certified technicians, we are at just over 46,000 for the total population. This license type, it's not a high percentage, as you can see. We've issued 11 licenses, or certification cases is actually what they're called, for this particular license type. And then all of the total combined, we have our new licenses issued at almost 65,000 for the third quarter. Renewed licenses is just over 29,000. Total population, we're at 49,787. That concludes my report. I will be happy to answer any questions that you may have.
This is Jerry Bittner. Does anyone have any questions for Lisa on the licensing division report? If not, I don't hear any. Can we move on to item F2, customer service division statistics?
Thank you.
Greetings. I'm sorry, greetings advisory board members and TDLR staff. My name is Dawn Robinson. I'm one of the managers here in customer service. We have an actual breakdown of our fiscal 2021 emails and phone calls. So from September of last year up until May, we've had a total of 2,059 emails and a total of 18,171 calls. And those are our customer service statistics to date. If you have any questions, I'll gladly here to help you.
Does anyone have any questions for Dawn on the customer service division statistics? Okay, I don't hear any, so can we move on to item F3, enforcement division?
Hi, good morning, board members. Can you hear me?
Yes,
Good
we
morning.
can.
Thank you. Good morning, board members.
Yes.
My name is Amanda Barrera, and I'm a prosecutor in the enforcement division. I know you usually see John Medlock or Robert Reyes, smiling face, but I will be your new enforcement prosecutor from now on. I'd like to start off with a few personnel updates. We had a lot of movement happen in the prosecution section. First off, some well-deserved retirements. On November 6, 2020, Prosecutor Ken Sharp retired after 7 years of service with TDLR and 13 years of service serving the citizens of Texas. Ken worked briefly on the transportation team before making his mark in the criminal history review team. Ken was also the co-founder and the first commander of the department's Veteran Association. Also on December 4th, 2020, Prosecutor Michael Shirk retired after 8 years of service with TDLR and nearly 2 decades of service to the citizens of Texas. Michael was a member of the transportation team and greatly contributed to the protection of Texas citizens, especially in consumers being deceived into unnecessary costly repairs. With the retirement of Ken and Michael came some big shoes to fill. 3 attorneys, myself, Arusa Nizami, and Natalie Olvera, were promoted to Attorney 3 positions. We previously had worked on inspection cases and ACR and electrician unlicensed cases. Arusa and Natalie have joined the transportation team, and I have joined Robert Reyes on the building and mechanical team. With those promotions came 3 Attorney 2 vacancies. Sarah McKinney, Rachel Sisson, and Hunter McKinley were hired to fill those vacancies. Those attorneys will be working on those inspection cases and our unlicensed ACR and electrician cases. Also in the enforcement division, on January 4th, 2021, Arthur Arevalo was hired to fill the investigations manager position. Art retired from the Austin Police Department after nearly 26 years of service. And since then, he worked for the Travis County Sheriff's Office and more recently served as the captain with the Texas State University Police. So congratulations to our retirees. our promotions and a big welcome to our new hires. So I'd like to dive into the statistics now. As you can see here, we kind of break it down between our ACR program and TDLR as a whole. We'll be discussing fiscal year 2021, which began on September 1st of 2020, and this will go through May 31st of 2021. Here we have our performance measures. These are what the legislator looks at. You can see that in in fiscal year 2021 through May, we opened about 600 cases in the ACR program and just about 7,000 cases for the agency as a whole. So ACR cases accounted for about 8% of the total cases, which is up about 1% from fiscal year 2020. As a side note, we recently completed a sting in Houston in early June. This was the first sting since COVID hit, and we were able to generate about 45 unlicensed activity cases across both the ACR and the electricians programs. These cases are not reflected in these statistics since these statistics only went through May, but stay tuned and I'll have some more details on this at the next advisory board. We closed 682 cases in the ACR program and about 7,000 for the department. The average time to close was 278 days, where the average time for the department was 205. But as you can see, we resolved within 6 months over half for ACR. And the cases that resulted in disciplinary action is about 11, and the agency is right there at 15. There are still 670 cases pending at the end of May. So next, it's the next graph. You can see the breakdown of where these cases came from. 70% were consumer-related cases. 3% were departmental cases, and that's where we open a case because of industry contacts, or maybe during the course of the investigation, we determine that an additional case may need to be opened. And then 27% of these cases are criminal history. And this is where we look at the applicant or the licensee to see if they're fit for licensure. On the next page, you'll see our case outcomes. First, we have it broken down into different types of orders that we have in this program. So we had one case that went in front of the commission. This means that the process went from us sending a notice of alleged violation, or what we call, and you'll hear us call, an NOAV. They requested a hearing. It went in front of the State Office of Administrative Hearing, and then the commission had the final ruling on the case. We had about 50 defaults, which basically meant that we sent out one of those NOAVs and we didn't get a response from the respondent, and a default order against them was issued. Lastly, we had 29 agreed orders that were signed, and this again is where we issued a notice of alleged violation. The respondent responded to us, and we entered into some sort of agreement with the respondent to either pay an administrative penalty or even possibly some license sanctions. For the program as a whole, we assessed $335,000 in penalties, and about $53,000 of that was collected. I know that this number seems a bit low, but I think this reflects how aggressively we're pursuing unlicensed cases. As I mentioned, we conducted a sting recently. So in this program, we actively seek out unlicensed activity, and it's actually one of our top violations within this program. Additionally, the penalties we seek in this profession are higher, but unfortunately, because they are unlicensed, they don't have a fear like a licensee would of losing their license, which is why some of them tend to hide, or they don't respond to our letters or refuse to pay. But we feel pursuing these cases and imposing these penalties is worth the work if we can notify them of the repercussions and deter any future violations. But this doesn't mean that we don't attempt to collect. We have policies and tools in place, such as debt collectors, and we can recommend an injunctive release to the Office of Attorney General, which can possibly impose criminal contempt for future violations. As you can see in our program-related cases, we revoked 8 licenses and suspended 2 licenses, and those stemmed from either an agreed order or default order. Next, we have our license denial revocation stemming from criminal history, and that was at 15. And we also issued 1 cease and desist order. For ACR, we informally resolved 591 cases, and this outcome can be negotiated other than an administrative penalty. For instance, the complainant can withdraw their complaint, the respondent may have made some corrective action, And so we issued a warning. Maybe restitution was negotiated for the consumer. And so that brings me to my next point as the consumer restitution through negotiated settlement, which was $38,210.88. That makes up about a quarter of the whole total that TDLR and all of our programs was able to negotiate. So in this next section, we have sort of a funnel effect to show you specifically how consumer complaints are being resolved within the ACR program. We received about 600 consumer complaints, and out of those, about 429 cases were open. This number is a little lower because we get complaints that could be duplicative, or sometimes it could be something that we don't have the law rule to regulate, such as pricing and those kinds of things. We had 370 of those consumer complaints that were informally resolved, and about 90 of those were issued notice of alleged violations, and 64 of them resulted in disciplinary action. So next we have our top 10 violations at opening for fiscal year 2021 through May. These numbers reflect the allegations listed in the complaint and when the case is first opened. As you can see, criminal history, mechanical integrity, and unlicensed activity are three biggest violations at opening, being over 100. And then misrepresentation of services and advertising without a license make up the next ones at about 40. And then we have some smaller violations such as no license number on the ad or no license number on an invoice at about 20 and under. Next, we have our top 10 violations that resulted in disciplinary action. So these are the cases that have gone through the entire process. They've been investigated. The prosecutor has issued a notice of alleged violation, and then some type of order was issued, whether that be the default, an agreed order, or a commission order. So our top 10 here, as I mentioned before, our top one is contracting without a license, that unlicensed activity, and that's at 32 cases. Then we have criminal history with 13 and mechanical integrity at 8. We then have other violations such as no license number on the invoice or advertising without a license that have a lower case count. Generally, we try to work with a respondent to come into compliance in some of those cases. So I'd like to move on to some case highlights, and I'll run through these a little quickly. We have fiscal year 2020 statistics here that you heard at your last advisory board member, but they're there for your reference. So I'd like to talk about the first case is Anton Lawrence Thomas. This first case is regarding a respondent, Anton Lawrence Thomas, who failed to perform a manual J calculation while replaced in an APR system. He entered to an agreement with us and was assessed a $3,000 penalty. Respondent is currently on a payment plan and to date has paid $1,500 of that $3,000 penalty. Next, respondent Lee Roy Porat, he failed to obtain a permit in this case. He accepted responsibility for the violation and was assessed an administrative penalty of $1,000, and that total amount has been paid in full. So to highlight some of our unlicensed activity cases, we next have respondent Sean Adams. Respondent there performed ACR work and was paid $2,500 for this service. He did not timely respond to the department, and so a default order in the amount of $4,000 was entered against him. Next, we have a similar unlicensed activity where Jose D. Santa Maria was entered into a default order against him for $3,000 when he advertised on Facebook ACR repair services without being licensed. So this last case I'm going to discuss with you today is regarding a restricted license. Before I go into the specifics regarding this case, I'd like to give you a little background on this new power that the Texas legislature has given us. So what this license seeks to do is create a pathway for those who have a criminal history and normally would not be eligible for a license within these programs, but have rehabilitated themselves. A restricted license allows the licensee to do anything a standard license would let them do, except with additional restrictions that resolve the department's concerns regarding their criminal history. So some of these restrictions may include being supervised at work, only working in industrial or commercial settings, only working for a particular employer or a particular supervisor. A licensee supervisor is also required to enter into the agreement, and they must ensure that the licensee complies with the conditions in this agreement. It also authorizes TDLR to impose an administrative penalty or other sanctions on the restricted license holder or the supervising licensee for violations of these provisions. The license is for a term of 1 year. After that 1 year has expired, the presumption then is that they're eligible for a full and unrestricted license, unless the department believes and can prove otherwise. So far, since the bill was passed, we have issued a total of 10 restricted licenses in both the electricians program and the ACR program, but only one has been issued in the ACR, which is what I'm going to talk to you about today. So on February 2nd, 2021, the executive director signed an agreed order that finalized the settlement agreement between the department and respondent Isaiah Ibarra. Respondent filed a renewal for his ACR technician license, and before the criminal history was done, the department renewed the license. During the subsequent criminal history investigation, the department learned that respondent failed to disclose a new offense for which he was charged and placed on deferred adjudication. The offense was directly related to the duties and the responsibilities of an ACR technician, as reflected in our criminal conviction guidelines for this ACR program. A notice of alleged violation was sent to the respondent proposing to revoke his technician license. Respondent requested a hearing and a proposal for decision was issued, with the administrative law judge also recommending to revoke the respondent's ACR license due to his criminal history. On December 8th of 2020, at the commission hearing, the commissioners remanded the matter back to the department to issue this restricted license. And an agreed order was entered into with the department, respondent, and respondent supervisor. The order imposed specific terms on the restricted license, including that respondent may only work under general supervision of the named supervisor. He may only work in new construction, industrial job sites, and commercial buildings, and is prohibited from working in any residential areas. And additionally, the respondent supervisor agreed to ensure that the respondent follow and comply with each of the restrictions, as well as all the ACR laws. So I know it's a lot of information. That's all I have for you today, but I'm happy to answer any questions.
Jerry Bittner. Does anyone have any questions for Amanda on the Enforcement Division report?
Do not.
Okay. Has Doris rejoined us?
Yes, sir, I have. So my apologies there for the bad Wi-Fi connections that I have here at home, and I'll do better next time. No, I do not have any questions, and I don't want to prolong the meeting. I think I missed. There was a question I had on some reporting, but we'll get to that at a later date. It's not actually that important. I had a question as to we have certified, and then we have a license, and then we have our contractor's license. I think on some of the reporting, are we all reporting it as license issues, and should another category be created for certified technicians? Because I thought maybe I just confused the report. But can you back up a couple of screens on the statistics?
On the statistics for enforcement, or the statistics for license?
Is for statistics, the licensing division. Right there, that page. So see, they're all being called, all of this is all being called licensing. Should they all be categorized as licenses, or should that be one category be a certification? I'm sorry. That's just a thought. I was looking at that over, and I was it may skew the number on the actual term license versus certification. Just a thought. That's all.
Am I allowed?
Chairman Compion, go ahead, Lisa.
Oh, David, if you want to, it doesn't matter.
Chairman Compion, I appreciate that distinction. So as you know, you're familiar with this. We have registrations at our agency. We have certifications at our agency. We have licenses. They're usually referred to as a hierarchy, but most of our reporting, we do typically just say license types in the general title. If you'd like to see that distinction, I think we could accommodate that, Ms. Lisa, but want to make sure that it's something we have maybe for the next advisory board, if you'd like to see those distinctions between the two.
Absolutely. If you would, please.
No problem. Thank you.
No, thank you. Appreciate it. And Mr. Bender, if you can just hand it off to me, where were we at? I think we were moving to item.
We were ready to move on to item F4.
4. All right. Well, thank you with that.
We'll hand it back over to Mr. Campion.
All right. Well, with that, appreciate it. Appreciate that. And so with that said, we'll move it on to Mr. Strawn there for the examination division.
Good morning, Chairman, members. My name is Michael Strawn. I'm the manager for Education and Examination Division, here to give you our statistics for exams. For 2021, as you can see, we're pretty much on pace for where we were last year on our total examinations. This year, we're up to almost 2,000, and we still have 1 quarter left to report, whereas we had 2,200 for the entirety of last year. I'd like to point out that's a significant accomplishment because of the COVID requirements that we had this year. Ever since they came out last year, we were stuck with a 25 and then 50% capacity until recently when we were able to open up fully. It was a very big process for us to make sure that we created availability for people to test so they could obtain their licenses. And so looking at this year, it may look like it's a little, it's in line. I think we're going to actually be over where we were last year. And I just wanted to point out that that was, through the dedication and hard work of a lot of our staff, and making sure that we had that availability, working with our vendor to create those opportunities and those testing, even though we had social distancing and limited opening that we could offer in the state. So we can scroll down. This is just the breakout of those actual pass rates from above. I don't have anything significant to point out on this page, so if you go down. Our continuing education statistics and approvals are in line. They seem to be normal with other years and prior. Continue down. And then we have our first time pass rate comparisons as requested from us. And here you can see the first time pass rates compared to all pass rates for all the different breakout types. You'll see that the ACR certified technician is a little bit lower than others. I do not have an explanation for that, but everything else is looking in line, and the statistics there. I have opened for any questions you all have at this point in time. That concludes my report.
Thank you for that. I do have a question, and I think we touched on it in the past, but is there any statistical data that where the individual retakes the test on the second time and passes it on the second time or the third time? I don't know if that's just too much analytical data to filter through, but there was some curiosity on my end as to how many failed the first time, how many failed, the same person fails the second time and passes on the third time.
Yes, sir. I do not have a statistical breakout of specific individuals at their pass rate at their second time, their third time, or their potential fourth or more. We can look to see if that is possible to grab, but I do not have that data in front of me at this point.
My thoughts on that, and maybe some of the board members will agree or disagree, was that how many others just kind of taking the test to take the test to take the test, and eventually they'll clock in and pass. I know that there are some, and it's just for my information as well. So that was it. That was the theme behind it. Nothing, no hidden agenda or anything like that. Just kind of curiosity.
Yes, sir.
Thank you so much. I appreciate it. And so with that said, we'll move on to F5 with Mr. Weatherly.
Well, good morning, board and participants. My name is William Weatherly. I go by Bill. I'm the Air Conditioning and Refrigeration Chief Inspector and Program Specialist, and I'm going to give the report for Regulatory Program Management section today. For the benefit of Mr. Graves, our new board member, Regulatory Program Management is made up of subject matter experts and administrative professionals, and we support other divisions, specifically enforcement, education, and licensing. And I will start with personnel updates. The building and mechanical area of RPM, which is Regulatory Program Management, which includes air conditioning and refrigeration, has a new section manager, and that's Chris Russey. Chris is my immediate supervisor as well. The previous manager, Yvonne Feinlab, retired in March after many years of state service. Chris has been with TDLR since 2014 and was promoted from his previous position as management analyst. If you're online, Chris, you might say a word.
Yes, thank you, Bill. I appreciate it. Yeah, as Bill said, my name is Chris Rusty. I'm the new section manager for building mechanical and RPM. Many of you I've worked with over the years. When I was in the enforcement division, anytime we updated the penalty matrix and more recent conversations on complaint prioritization, great meetings over the years, and I'm looking forward to working with y'all in this new role. If y'all need anything, please feel free to reach out, and I'll give it back to Bill.
Thank you, Chris. Go into current projects and activity. Start with consumer protection, ACR disaster response. I worked with Public Information Officer Tila Mange and Communication Specialist Doug Van Pelt, and we created a consumer protection handout. It's entitled When Disaster Strikes, TDLR's Disaster Response Team Rolls into Action. Now, you have a copy of this in your packet there, and you can look. Now, this is going to be available on our website, and it's also a handout that we can use when we go to an expo, or we can send to someone just for information on how we react to situations like Hurricane Harvey, those type of things. Also working with Media Communications Department, we teamed up to produce a YouTube video. It is entitled Hiring a Licensed ACR Contractor. I had planned on showing this during the meeting, but we found out this platform didn't support that very well. So that is in your packet, and at a later time you can click on that and look at the video or put that in your browser. And I would like some feedback on that. Let us know what you think of the video. Did some television interviews. I was interviewed by Carla Drexler of KTSM Channel 9 El Paso for a nightly news segment. It was entitled Fixing Your AC Before El Paso's Summer Heat Can Save You the Stress and the Money. And I put that in directly like that. If you go to KTSM's website, you can, if you put in the exact wording that's under the parentheses, I think it'll pull up in their archive if you'd like to watch that. As far as public outreach, part of what I do, the travel, of course, was curtailed in the last year and was not able to do a lot of that, a lot of public speaking, but I did participate in a mechanical codes presentation to the Houston TACA chapter. That's the Texas Association of Contractors. And the meeting was in person by the TACA chapter members, and I attended electronically via Zoom, and we had a very good meeting. Also electronically attended and participated in a Q&A session with the Panhandles Inspectors Association in February. This is the second time that I have spoke with them and participated in their meeting. The first time I actually traveled to Amarillo, and they have a very robust group up there, and I always enjoy talking to them. Normal duties of mine, public inquiries regarding the air conditioning refrigeration program were sent in by customer service, and we get quite a few of those. I average 4 or 5 a week, and I try to be very responsive and get back to them the same day. And also ACR license application reviews. This is mostly concerning out-of-state applicants. When they come in, someone from out of state that wants to do business in Texas, we'll need to review them to make sure that they are experienced and qualified, and what they have gone through in their state for licensing at least mirrors to some extent what we have in Texas. And then if they're approved, then they don't specifically get the license, then they can take our exam. If they pass our exam, then they can do business in Texas. We also have a reciprocity, but our reciprocity is only with Georgia and South Carolina, and that's something that we're working on. I've worked a little bit with Louisiana, and that would be very beneficial if we had reciprocity with our neighboring states. And Hurricane Harvey and also Hurricane Katrina. Contractors could work across state lines, and both entities, both states knew that they were qualified. That would certainly be helpful in a time of disaster. So we're working on that. Also review ACR exam questions that score outside a set of parameters. I also participate when we do an exam review, and those happen a couple of times a year, especially when things change. Like this year, we adopted the 2018 international codes and also the IAPMO codes. And also when we also changed from adopting our technical standard that we use, modern refrigeration, we went to the next update of that. And so when we have something like that, we always have a review. Also review and inspect enforcement cases with mechanical integrity issues. And all reviews have been electronic since March of 2020, although we're opening up again a little bit that way. But I did do an Apple FaceTime on a complaint in Tyler, Texas that was a little more in depth, and that worked out pretty good. And so going forward on a case-by-case basis, I can travel and I can do an inspection, on site. Get on to some of the issues. Now, you heard about this issue, the 2020 National Electric Code, earlier in some public testimony, and we will also be talking about this later, probably Doug Jennings. But what this did, it required certain outdoor outlets to have ground fault circuit interrupter protection, and it specifically included ACR split system condensing units, and that's where the problem came in. Adoption of this rule by the state and local municipalities and the implementation by licensed ACR contractors has resulted in the equipment failing by persistently tripping circuit breakers. And we looked at this. I received about 150 emails and complaints across the state. The municipalities had adopted this rule, tried to implement it, and with not very good results. Systems were tripping, especially on new construction. Now, this is we looked at this. The approaching summer heat poses a serious threat to Texas residents whose air conditioning systems has failed or malfunctioning. That goes without saying. To help alleviate this threat, the Texas Commission of Licensing and Regulation at a meeting on May 18, 2021, adopted an emergency amendment to ACR Rule 75.100, and that rule was the one specifically addressing this, to delay the applicability of Section 210.8F of the National Electric Code. The Commission voted to amend the rules in the electricians and the air conditioning and refrigeration contractors programs to delay the effective date of this section until January 1st, 2023. The effective date of this emergency rule is May 20th, 2021. And I have heard from a couple of municipalities, and they have since amended their local rules. I've heard from Pflugerville and from Austin as well. And then I heard from Houston the other day as well. And so I think they are getting the idea, and the contractors are telling them to look at the TDLR website, and because this is definitely a problem. As I said, we'll be talking more about this later in the meeting, and I will close now. And if anyone has any questions for me, I'd be glad to answer.
All right. Any board members have any questions at this time?
No.
Mr. Weatherly, I actually do. It's about reciprocity. Not to put you on the spot, but
no, go ahead.
With our neighboring states, Oklahoma, Louisiana, what is some of the obstacles that we can help with on crossing that bridge?
Well, it is a process, and with Louisiana, I have talked to their department over there, but it's been a year ago. COVID actually put this on hold for a while, but it's just a matter of getting together, coming up with some draft rules, and making sure that it is compatible with both states. And then this, has to go to the governor's office as well. So I am ready. I've talked to Doug Jennings, who, is our general counsel liaison, and it's something that I think we are ready to roll with. So, help from the advisory board would be welcome on on that because I think it's needed, especially the neighboring states. If we could have reciprocity in Oklahoma, New Mexico, Louisiana, that would be a great thing, I think. So,
Yeah, because I know that.
but it is a process.
All right. I know that Louisiana has a board as well, so maybe entertaining some diplomacy there, and that's why I was asking that piece. I think currently we have a reciprocity with electrical journeyman's license. I think if I'm not misstating that.
Yeah, the electrical side, they have actually a national organization that looks into that, and they've been very aggressive with that. And air conditioning, refrigeration needs to follow suit, I think, and that would benefit citizens of Texas and our neighboring states.
Well, thank you so much for the report, Mr. Weatherly.
Yes,
so,
sir.
With that said, we'll move on to item F6, the executive. Ms. Winston.
Good morning. Good morning, Mary Winston, TDLR. For this executive report, I am honored to have two of our deputies present. We have Ms. Christina Kaiser and Mr. David Gonzalez. And actually, if I put together the years of service that both of these folks have, it's almost as old as I am. So I'm going to leave that there. They've been here for quite a while. So for the first item, our deputy, we call him our DEDS, Kaiser will take that. And our second item for the legislative session update will be Mr. Gonzalez, and I'll close out the report. Christina?
Thank you, Mary, for that introduction. Good morning, ladies and gentlemen. Again, my name is Christina Kaiser. I am one of the Deputy Executive Directors here at TDLR. My area of responsibility is regulatory services. So I'm responsible for the enforcement, regulatory program management, and field inspections division. Great group of folks. I wanted to talk to you a little bit about the agency's response to the COVID pandemic. Now I'm going to pop some notes up on my screen, so if it looks like I'm staring off into space, I really am still with you. So when you met last in October, we would have updated you about our COVID response up to that point, and so I'm going to try not to repeat all of that in detail because it was a whole lot. Like all organizations in the country, in the world, we have not been immune to the impacts of COVID. We have done what every other organization has done. We've tried to find our way, learning as we go based on the best information that was at hand at that time. We did take several key actions to help our licensees navigate the pandemic and help to ease some of the regulatory burden because of everything else that people were having to deal with and to some extent are still having to deal with. We did seek, we obtained Governor Abbott's approval for multiple waivers of rule and statute provisions, including in our health programs, the expanded use of telehealth services, so like a remote doctor's visit. We temporarily suspended, with the governor's approval, continuing education requirements for certain license renewals for a limited period of time. We waived late fees for late license renewals for a limited period of time. We allowed, and we actually are continuing to allow now, schools and continuing education providers to use virtual learning and other virtual types of techniques to deliver education as an alternative to in-person, in the classroom type of training. As I said, we have not been immune to the impacts. We did have to shut down certain divisions of the agency multiple times because of COVID positive test results. That included our financial services and in particular our mailroom on multiple occasions. I think that also impacted our licensing division and our enforcement divisions and probably others that I can't remember at this time. As you might suspect, the pandemic impacted our ability to move the volumes of work that are TDLR's responsibility. And so we have seen backlogs of work build up as a result of these shutdowns and just as a result of the safety protocols that we've had to put in place to kind of limit staff presence in the office. To walk with our licensees, as our chairman likes to say, we did issue 120-day emergency licenses for licensees whose licenses were expiring during a particular range of months. And that was recognizing we're probably not going to get your renewal done on time, but we want you to continue to be able to work and not have a gap. And so that emergency license would just tack on at the end of their renewal until we could catch up with the work. I know that the first such emergency license time period was August 1st, 2020 through January 31 of 2021. And I believe there's been another extension since that time, but I'm sorry, I don't have the dates. David may have those dates, and he can share that with you when he's ready to start talking to you. So as I've mentioned before, when I've talked about this, our response was kind of twofold. I told you a little bit about our outward looking response related to our licensees. There's also been a whole lot that we've done regarding our employees, just to help them remain safe. You know, safety has been our top priority through all of this and continues to be today. So in March of last year, March of 2020, we started having a large contingent of our Austin staff working from home. We have maintained a limited staff presence in the office, largely on a rotating basis for tasks that cannot be completed in a remote setting. We of course are keeping protocols in place to ensure staff safety. We did stop all field activities, including inspections and investigations. At that same time, March of 2020, we restarted those activities in the field in fall of last year on a reduced basis. We were monitoring the COVID positivity rates and the hospitalization rates by county across the state. And we were making decisions to put certain counties on the no-go list, meaning we're not going to enter that county when those numbers were above certain levels. Chris Russey was front and center in all of that, and the analysis was largely his baby, and he did a great job with that. At the same time, as we had certain counties that we weren't going into, we were also engaging in virtual inspection techniques and virtual investigation techniques, such as those that Mr. Weatherly talked to you about a little bit earlier. And we also, for a time, stopped all non-essential travel, which includes travel for speaking engagements and other industry events. We are proud that during this time, we were able to adjust our ability to hold meetings. And so we've held over 40 virtual, meaning online, advisory board and commission meetings. And during those virtual meetings, at least 180 members of the public have been able to participate online in these meetings. So where we are now in terms of our COVID response, our field activities, including inspections and investigations, are back in full force. We no longer have any counties that are on the no-go list. We are, however, still using some of those techniques that we learned, virtual inspections, virtual investigation things, when those can appropriately serve our needs. That is a way to be more efficient, and we certainly aren't going to throw out something good that we learned. We are working toward increasing the amount of staff that we have working in the office, again, keeping appropriate safety protocols in place and continuing to monitor the state of the pandemic. You know, we're in a much better place than we were a year ago, but you know, we continue to hear about, you know, different strains and variants of the virus, and so we're continuing to monitor that. We are still working through those backlogs of work that build up during the worst days of the pandemic. Staff from across the agency are assisting each other, assisting licensing, assisting customer service, other divisions where help is needed. And those numbers are looking better every day. And we are starting to participate in some speaking engagements and industry events again in person. And that's still being approved on a case-by-case basis. But I expect that will continue to increase. I'm happy to answer any questions that you may have about our response. In the absence of questions, I'll yield the floor to Mr. Gonzalez.
Ms. Kaiser, I do have one question, and one of them is, the whole pandemic, we've learned actually quite a bit and continue to learn. Do you find that the public participation is better online or is better in the present? Have you seen an increase?
We have definitely seen an increase in the amount of public participation since they are now able to do that remotely. The quality of the participation is sometimes a little difficult. We do have technical struggles from time to time, like today with our public commenters, but we're getting better every time we do this. And my personal observation, I think it's worth it to learn our way through those technical struggles to have the greater access for the public.
And I know there's always a strategical plan. In the future, was there some thought as to integrating the virtual meetings versus in person, maybe make an integration for more public participation? Has there been some conversation or some thoughts in that?
So our commission is working in that direction right now. They are hoping to hold not the next commission meeting, which will be July 6th, but the one after that in a partially in-person, partially virtual format. Like everything else, that will be an experiment and we'll see how it goes. I can tell you that, and we'll talk about the legislative session in a few minutes, but one of the things that we were granted during the legislative session was authority to continue holding advisory board meetings online on an ongoing basis as much as we feel we need to. So that's going to be a big help. We're not going to have so much pressure that we have to have you guys all back. We certainly can on occasion if we want to, though.
Thank you for that. Appreciate it.
Thank you.
So if there's no more questions, this is David Gonzalez, Deputy Executive Director of Licensing Services. I'm going to pick up and piggyback on what Ms. Kaiser presented regarding the COVID response. I'm going to try to share the screen because I think it's important that not only advisory board members be able to see it, but the public be reminded of where we have this information. So I'm going to attempt to share. Hopefully I'll get the right screen up where everybody's looking at what I'm looking at. Share. Someone could give me a verbal, I see it when you see it. That would be awesome.
I do not see it.
See, it's thinking, it's thinking.
It looks like it's coming. There it is.
Are y'all seeing the TDLR screen says emergency license extensions due to COVID?
Yes.
All right. So as Ms. Kaiser alluded to, we try to communicate this information to the public as much as we can, as quickly as possible. The latest emergency license extension goes all the way through September 18th, 2021. Again, recognizing that we've had some backlogs, turnaround times on some of our license applications, especially the more difficult, more involved, the ACR and electrician applications actually require individuals to look at experience and have the master electricians or the ACR contractors verify experience. Those are the more complicated ones. And so sometimes there's lacking information. So a request for additional information goes out to the applicant. We're trying to reduce the amount of RFIs, requests for information, and try to process things via emails and phone calls, but that's not always possible, especially if someone's not on the phone line. If they're at work, it's difficult to make contact. But this emergency extension was, as Ms. Kaiser put it, us trying to walk with our applicants the best we could and understand that if we have an obligation to turn around applications and get their licenses to them, we don't want them penalized because of our backlog. So we pursued this to help provide some relief, and we think it's been successful in many instances. Again, some instances they're still lacking documentation that we need to follow up with our licensees. Another effort that we went through, and this was an agency-wide effort, we called it the Strategic Workforce Allocation Team, SWAT for short. We actually drew upon all the resources in our agency from different divisions, not just the licensing division, anybody that had previously worked in licensing, anybody that had experience with a particular program that could benefit us in processing licenses. We asked for their assistance, and allotted time for them to actually help us process applications to the extent they could. Some of them have full access and could actually process an application just like our licensing staff. Some of them only had technical capabilities, so they would review certain aspects of the application or do returned mail for us if there was addresses that were wrong. It was truly an agency-wide effort, and it's ongoing right now. As you saw in this posting that's on our website, through September 18th, we're hoping to catch up, and we're doing a phenomenal job. We're making great progress, again, due to the efforts of our agency staff. I'm going to try to stop sharing my screen now so that I can just talk to y'all and see y'all's faces while I'm talking. Give me just a moment while I figure that out. Shared, stop sharing. All right. So now I'm going to turn to the legislative session, which just about everything we do at TDLR is a team effort. I want to make sure that y'all understand that the legislative session, even though there's a few individuals that get a little bit more play than others, it really is everybody, all hands on deck to get the work done. Our executive director, Brian Francis, would be the first to tell you that even though he gets the accolades and a lot of times he gets the phone calls to come discuss, or if he's the one representing us at a hearing, he's going to be the first to tell you it doesn't happen without the research and the bill analysis. There's fiscal note research, countless meetings that we have to have with technical subject matter experts, with our finance team, with our general counsel. All of these things are happening behind the scenes so that when we are asked to attend a hearing, we're prepared, and all the efforts that go into it are very difficult and very involved. But I want to recognize just a few names, and you don't get to see these people in these advisory board meetings very often, but I want you to hear these names because they've been perennial through our agency for years. These individuals have contributed. One name is Steve Bruno, who's one of our government relations staff. His contacts, his ability to keep us in the loop. Jeff Kopus, he's the one that actually assigned responsibility for tracking all of our bills and legislation, staying up late nights. Sometimes we're getting emails and notifications up until the wee hours of the morning on new legislative bills that have been filed and how they might affect our agency. Jeremiah Kuntz, who's a new addition, and you may recognize the last name, former executive director, Mr. Bill Kuntz. He's definitely related to Mr. Bill Kuntz, but Jeremiah has been a great addition to our staff. He came over from DPS and has just hit the ground running. Started out as a management analyst and now in our government relations office. He's just got years of experience. And then last but not least, Jessica Escobar, one of our general counsel, who has years of experience from Texas Department of Agriculture, brought that experience to us and just has been a phenomenal contributor to the process in reviewing bills and trying to get meetings organized. So again, we can keep Brian and the rest of our staff, including all the executive staff, up to date on the bills that are affecting our agency. Strangely enough, and I know we met in, I think it was October of last year, September, October of last year, things are kind of getting rolling with the before session, but the session got off to a slow start because everyone's trying to figure out how they were going to hold the hearings in person, like we're used to, or virtually like we're doing now. And our staff attended hearings in person, had to get tested. They had to mask up. There's protocols that you have to follow in the Capitol. So all the staff that were going to actually attend the meetings and make sure we were there to represent the agency's interest had to do a lot to keep up with that. And there was a lot of meetings. And although it started off as a slow session, it was as much of a roller coaster ride this session as any other session. The amount of bills affecting us and how they affected us was significant. I'm going to touch on just a few bills, and I'm going to let Ms. Kaiser, because she's a great closer, she's going to finish up with our sunset bill, which is one of the most significant bills for our agency. But I'm going to touch on just a couple of bills that affected the ACR program, or had a touch on the ACR program that I think you need to be aware of. So one of the most significant and just kind of called out air conditioning as a program by itself was House Bill 871. It actually prohibits any municipality from charging a registration fee to a state licensed air conditioning and refrigeration contractor for work performed in the municipality. Now, it does not keep them from charging a building permit fee, and it's significant that this bill actually takes effect September 1st, 2021. Now, I want to assure you, the agency, we are the train on the tracks. the legislature passes bills that become law, and that's the tracks for us. We have to run the train on the tracks they provided to us. In this instance, we really don't have a lot of work to do except for communication with our licensees, because every municipality, and y'all know this better than I do, especially those contractors, they're going to do their business the way they do business, and we're going to have the questions. We're going to be fielding inquiries. Mr. Weatherly, I expect, will be pretty busy with the different situations that are coming up as we go through the session, but we actually have a bill implementation team assigned to this bill, because now that the bill has passed and become law, we want to get some word out to the public of what this may mean and what they may experience, maybe some FAQs. So it's a communication effort that we'll be going through for confiding in the public or sharing with the public what's happened with House Bill 871. Another very significant bill, it's actually something that we submit on a biannual basis. It's our legislative appropriations request and any exceptional items, the things that allow us to pay for our budget and the things that maybe go beyond our operating budget. They get submitted to the Governor's Office of Budget Planning and Policy and the Legislative Budget Board. Once everything's agreed upon as far as what we propose, it gets submitted as a bill. And of course, things can change during the legislative session. And if those bills don't pass, we may or may not have our money for operating or for exceptional items. I bring this up because one of the most significant exceptional items we requested, which would affect the ACR program and all of our programs, is our request for funding for phase 2 of the Texas licensing system. I think we talked about it at our last meeting, that it was something we were working on. We've got multiple disparate databases for the many programs. We have 39 programs, like about 9 different databases to have to deal with all different programming requirements. We're trying to get it to one. We are focusing right now on electricians and massage. Initially, it was going to be our bar cause programs, the largest programs, but because of legislative actions that Ms. Kaiser will probably touch on in her part, we're shifting gears a little bit and moving bar cause a little bit later to the mix. And so we're going to be focusing on electricians program, and because it's so similar to ACR, that funding, which we were approved for, close to a couple $1 million for phase 2, is very important for us to get onto one Texas licensing system. Should make it easier for all the online interactions that our public actually has been demanding, that most people request. They want self-service. They want to do everything that Google and Amazon allows them to do. They want to be able to do that on our website, and we just haven't been able to successfully accommodate all of that. We've been successful, but not to the level and degree expectations of our customers. So those are probably the 2 most significant. There was a couple more bills, and the reason I bring it up is because Mr. Bittner actually asked that this be an agenda item for this particular meeting. We didn't include it as an agenda item because I was going to address it in the legislative updates, but there were a couple of bills filed for the proposal that the International Mechanical Code be the code for the state, and that the Uniform Code may not be included. Now, those bills did not get passed. I want to make sure and say that again. Those bills did not get passed. So the last advisory board, ACR advisory board that we had, there was some public comment. I believe Ms. Sadler had conveyed her interest in trying to forward that initiative for the ICC codes to be the only codes in Texas. But until legislative action is taken that changes our current statutory mandate, which requires that we adopt codes that are in line with the uniform and the international, we are still going to be continuing to do what we have been doing, which y'all have been used to. So nothing has changed, but that has come up a couple sessions now, and I just want you to be aware of it, that it has come up. Some people only read the initial bill that's filed. They don't actually wait to the end and find out if it's actually gone to hearing, been passed, or even, most importantly, been signed by the governor to make sure those laws pass. So those are just a couple of the bills that I think were significant for y'all's particular program. The rest of it, I'm not going to steal any of Ms. Kaiser's thunder because she gets the big one. But if there's any questions on what I've presented, let me know. Otherwise, I'm going to turn it over to Ms. Kaiser.
Any questions from any of the board members?
No.
Jerry Bittner, I had one question. If you could clarify, I think I heard you say in the communication outreach element, there was something regarding House Bill 871 and the addressing fees that municipalities might be able to charge. Could you clarify that?
Sure. So basically, the municipalities will no longer be able to charge ACR contractors a registration fee. That's what the bill passed says. How they implement it is not up to TDLR. We're going to be the communication point to our licensees that this bill is passed, but municipalities, I expect, because they typically need money to run their functions and their processes, they're probably going to be scrambling in the next few months, couple months, to figure out how that affects the way they do business. It did not prohibit them from charging a permit fee, which y'all are used to. That's how most cities do their business. But this registration fee was not necessarily in every city. It was in some cities, some of the major cities included, just to register contractors so that cities would know who's working in their space. That's no longer going to be able to be charged registration fees. So that's significant. Again, we're going to try to get some more communication out. If you wanted to see what the bill says right now, you could actually go to our website. The very first page has legislation affecting the agency. Click on that, and it's the very top bill because air conditioning's A. One of the first programs starts with the letter A. Y'all get top billing on our webpage for legislative bills. If that helps, Mr. Bittner.
Yes, that's perfect. That's what I thought I heard. I just wasn't sure.
Anybody else? All right. Well, you're the best part. Save the best part for last. Ms. Kaiser has our sunset update.
Hello again, Christina Kaiser again here. So again, last time you met, October of last year, I think we briefed you on this. TDLR has been under sunset review. This is something that all agencies are subject to on a periodic basis. And it is a review that's conducted by staff of the Sunset Commission, which is an actual agency of the state. And the purpose of the sunset review is basically to see if your agency is still adding value and is still relevant for the purposes that your agency was created for. And that's kind of funny in TDLR's instance because what we're responsible for continues to grow. So in the legislative session, after about 2 years of our staff working with the Sunset Commission staff, they definitely did a deep dive. They came in, our staff had at least 80, and it might have been more like 100 individual meetings with Sunset staff, answered umpteen questions and provided all kinds of information. The result of the staff review was the Sunset staff report that I think we probably briefed you on last time you were here, that was published in June of last year. So then fast forward a few months, when the legislative session started, the recommendations that were adopted by the Sunset Commission based on that report got converted into a bill that was filed in the legislative session, right? So that was House Bill 1560, filed by Representative Goldman. And I am happy to announce that TDLR's sunset bill did pass. It was no pressure at all. The legislature waited until the very last day that they could adopt anything to actually finally adopt our bill, because one version got adopted in the House and then a different version, containing different language, got adopted in the Senate. And so then when that happens, there has to be a conference committee formed up of members from both houses to get together and iron out the differences. And then both houses have to approve that conference committee version. So all that happened, but it didn't get finalized on the last day of session. And so we were sweating. But thankfully it passed. So the passage of our sunset bill means a couple of things. It means first and foremost, TDLR is continued in existence for 12 more years. So until 2033, yay for that. One kind of interesting detail about our sunset review, because we have had so much growth over the last 5 years, our sunset review that just happened was a limited review, and it only covered what's considered our legacy programs, like the ones that have been here longer than 3 years. And so all of the health related programs and the more recent programs that have come to us in the last few legislative sessions were not included in that review. And so we thought that after this first review, there was going to be another review two years later that touched on all those newer programs. But part of the sunset process, we were able to successfully talk them out of that. And so we will not now be subject to another sunset review. And it made sense because a lot of those programs, those new programs that came to us as a result of sunset review of other agencies. And so, you know, sunset was all over it right before they came to us. So give it a little time at TDLR. So that's another very happy outcome. So some of the key, I'll start by saying there was nothing in the sunset report that directly impacted, or in the sunset bill that directly impacted the air conditioning and refrigeration program. We did have a couple of deregulations. The polygraph examiners program is to be deregulated. There are 3 license types in the boxing combative sports program that will be deregulated or eliminated. That program will continue to be regulated, but just 3 of the license types will go away. And there were several other programs that were recommended for deregulation, but ultimately those did not get adopted. One of those was the auctioneers program. So instead of deregulating the auctioneers program, our sunset bill in its final form now requires us to conduct a study over the next 2 years, working with the advisory board and with that industry to come up with recommendations for how to improve that statute, to modernize it and strengthen it on the regulatory elements of it. Big changes are on the way for the barber and cosmetology professions. Those two, you might not be aware, but those 2 professions have existed under separate statutes and separate sets of administrative rules since they came to TDLR. Before they came to us, they were 2 separate agencies. And so Sunset took the very bold move, and the legislature agreed that those 2 programs should be consolidated into a single statute and ultimately a single set of administrative rules. And so the Sunset bill made that consolidation in the statute, but now it's up to TDLR to catch up with that in terms of how we issue these licenses and what our rules look like. So that's going to be a whole lot of work in place ahead for the folks who are on that bill implementation team. Another big change was that our driver education and safety program was greatly revamped. And the point of Sunset's work on that statute was to simplify the statute and to remove some layers of regulation that Sunset felt were unnecessary or perhaps overly burdensome for the profession. The other big thing I would say that came out of Sunset was it's all contained in Article 1 of the bill, and these are things that relate to TDLR and how we function as an agency. There are changes related to enforcement and inspections. There are some new requirements that we approach those things on a more risk-based in a more risk-based way. And so actually a work group of this advisory board, I think, has already had some conversations with enforcement about what complaint prioritization is going to look like going forward. So proud of them that they've gotten right on and started working on that even before the Sunset bill was passed. Some of the other things are, as I mentioned earlier, we can continue to hold advisory board meetings in a remote manner going forward. There's also a new opportunity for us to create multidisciplinary, I couldn't get the word out, multidisciplinary advisory boards, where if there is an issue that affects multiple industries that are under our regulation, rather than meeting with 3 advisory boards separately, we can pull members from those advisory boards and create a multidisciplinary group for that specific purpose and carry out that work, kind of have a one-time conversation with all of the industries involved. So we're really excited about that. And I can see that possibly being something that we do as we are starting to implement some of the risk-based stuff. But we'll see what happens. I think I've probably left out a whole lot because there is a whole lot involved in our bill. I would urge you, if you haven't already taken a look at it, read House Bill 1560 in its final form. And in association with that, read the Sunset Staff Report that was published last June, which contains, not only the statute change recommendations, but it also contains management action recommendations that the agency is expected to execute as well. I'm happy to answer any questions. Sorry, that was a lot of information.
I do have one question, and there may be have some dialogue in reference to this. Did Sunset make any recommendations or prop up our enforcement division? Because when you look at the reporting with enforcement, you have financial penalties assessed, and then you have what they collected. There's an enormous disparity between one and the other. Was the agency given any latitude on the collection piece of that process?
No, Sunset didn't. The bill didn't contain anything that has to do with collection of penalties in particular. The changes that are underway to make enforcement more risk-based. Am I breaking up? Because it sounds like it on the end.
We're good.
Okay,
We can
sorry
hear you.
about that. The changes that are underway to make complaints prioritized on a risk basis may result in some benefit on that end, Mr. Compion, because one of the things that we visualize happening is that as a result of the complaint prioritization, there will be some complaints that right now we spend time on that we may not spend time on going forward, to allow us to focus more of our resources on the truly bad actors. So we'll see how that plays out.
Thank you. Any other questions from any of the board members? All right. Thank you for the executive office report. Appreciate both y'all. Known y'all for many, many years. So we're still here, right? Still hanging in there. That's
Mr.
good.
Compion?
So, yes.
We have one more little part to this report that I'll be giving, really short, but now you see why I was so happy to have both of these DEDs here, Deputy Executive Directors, here today to present. They are a wealth of knowledge, and David has handled this program in his former position for years and years here at TDLR, and Christina was our Director of Enforcement for many years here at TDLR, so she has a lot of commerce with this program as well as the other ones that we do regulate. I just want to take a brief moment to give our communication outreach statistics. Short and sweet. Over the past 6 months, from December of last year to June 15th of this year, this air conditioning and refrigeration contractors website within our TDLR website has received over 203,000 views, averaging over 11,000 views a day. 43% of those visitors accessed the site from the desktop computer, 55% did so from a smartphone, 2% from a tablet. That kind of gives us an idea of, we're always talking about how can we do next practices, and we've batted around, is an app good? Can we develop that? But right now we're trying to get this licensing system up and running, and thank God we received the financing for that from the legislature. The top reasons for visiting the site: how to apply for a contractor's license. Second, exam information. Third, looking for forms. Fourth, how to apply for a technician certification. And finally, how to apply for a technician registration. So that's just a brief snapshot of our web activity over the last 6 months. And with that, we are wrapped up with the Executive Office report.
Thank you so much for that report. Any questions from any of the board members? And I think at this point we move on to item G and Mr. Doug Jennings.
Yes, thank you, Chairman Compion. And again, Doug Jennings, Assistant General Counsel for the department. I am going to share my screen real quick. Let's make sure I can do that. It appears that I can. All right, so what we're talking about for this agenda item, you heard our two public commenters and Mr. Weatherly allude to it. Our department and particularly our technical specialists have identified some issues happening in Texas. They're going on elsewhere too, where there is equipment incompatibility due to some of the changes wrought by the 2020 National Electrical Code. Just by way of background, we are required by statute, the department is required every 3 years by statute to adopt the new revision of the National Electrical Code. And our commission adopted the 2020 NEC, and it became effective last November. And section 210.8F is brand new in the 2020 NEC. And as you heard Mr. Weatherly mention, that is a provision that that requires a GFCI, ground fault circuit interrupter, to be placed on certain types of outdoor outlets, and often those service air conditioning equipment. And that inadvertently, of course, has led to a great number of systems failing, persistently tripping circuit breakers, which can essentially take equipment out of service. Also results in a lot of companies wasting a lot of time and money responding to calls where a circuit breaker is really the only issue. And those may be repeated. And so what our commission did, this is still background, when we became aware of this issue, I think anyone who's lived through a Texas summer understands that Texas summer plus failing air conditioner equals bad news and can equal a real threat to health and safety. And so the department asked our commission, our governing body, to adopt some emergency rules to eliminate or reduce at least the potential for these systems going offline during the summer. There is a mechanism in the Administrative Procedure Code that allows our commission to adopt rules on an emergency basis. And when they do that, it's temporary, and it's also without the normal publication and comment requirements that I went over in our flow chart earlier today. And so our commission met on May 18th and adopted emergency rules both in the ACR program and in the electrical program. And the text to the rule is identical to what you see on your screen here, highlighted. We just wanted to go ahead and get that ball rolling on an emergency basis so those rules would be in place and protect Texas residents from what could be a deadly situation where you don't have cooling during the summer. And so those emergency rules are in place. They became effective May 20th, are in effect for 120 days. They can be extended again for a total of 60 days. So while those emergency rules are in place, again, I mentioned that there were no public comments, no publications. We are coming in with a parallel rulemaking, which we are doing now, which is the slower, more measured rulemaking, where we ask for public comment, we publish in the Texas Register, and so on. And so again, the rule text is identical to what is already in place on an emergency basis. And you will see the proposed rule change right here, highlighted in blue. So I believe our technical experts and maybe our public commenters touched on some of the technical details, and we have Mr. Weatherly on hand to answer any questions you might have about this provision of the NEC, how it's affecting air conditioning systems in particular. But just to go ahead and get this out there, I assume there will be discussion. We have had both our commission and our staff members have looked at this issue and have determined that this change would not negatively impact safety. And we have also, our staff has pledged to continue looking at this issue. One of the reasons you see that we are delaying compliance until January 1st, 2023, is that we believe that that is the date by which all of the incompatibility issues will be resolved. If the manufacturers are able to resolve this problem, they're able to come out with new equipment in a quicker time frame, and we will recognize that, and we will try to pull this rule and change the effective date of this section 210.8F. So we are keeping our eyes on it. We want to make sure that we ensure maximum safety per the codes. and that we're not taking any risks. And I believe we are all satisfied that this is not a risky move, but it's necessary. So again, if you have any technical questions, Mr. Weatherly is on hand. So the motion, and once again, anticipating discussion, I just want to put it before you, is to approve this rule change as presented and publish it in the Texas Register, at which point we will publish the rule. That will begin a 30-day comment period. As I mentioned in my presentation earlier, we will take those comments, package them up, and bring them back to you probably in early September is my best estimate, and ask you to take a look at the comments and determine whether or not the rule should go forward from that point and be recommended for adoption by our commission. But I'll step back a little bit, and if there are questions, we're happy to field them. Thank you.
Yeah, I've got a question, and probably this is something Bill can answer. The ground fault, is that something that they're wanting put on the piece of equipment, or do they just want the breaker that serves like a condensing unit? Do they want that to be a GFCI type breaker?
Okay, Mr. Graves, could be two ways. That GFCI could be put in the actual breaker that serves that circuit, or it could be installed where the disconnect is. And air conditioning contractors are allowed to change a disconnect. What I've heard from the industry is that there is no GFCI breaker that can be switched easily and changed and installed at the disconnect. So what was happening on regular compressors, and I say regular, there's two parts to this. The industry, as you know, is going to inverter type compressors, and that means changing from AC to DC. So the compressor can be variable volume, variable speed, and it's more efficient. Well, those compressors will not work at all. I had a email and some comment from a contractor in Cypress, Texas, that did mostly new construction, and all the new construction that he did were high level equipment, 18 SEER and above, and he was getting 2 or 3 trips a day from every installation he put in, and it was a big drain. And he actually quantified what his service calls were costing, and it was $50,000 is what he came up with. And so that's a problem there, but also the potential is there for a regular compressor. And I think one of our public commenters talked about it. It's a matter of leakage to ground, and what that ground fault picks up. And so, yes, they're talking about putting the GFCI on that circuit, on that 220 volt single phase circuit going out to the condensing unit. And, it's not working. And I had a tremendous amount of feedback on that before we took this up with our licensing commission. Did I answer your question totally there, or is there?
Yeah, you did. I just was kind of wondering why equipment manufacturers were coming to us versus maybe an electrician that
Right.
was putting in a ground fault circuit breaker. But I understand. And yeah, GFCIs are a pain in the behind. So
they have their place. They really do, and they do save lives. Just on your outdoor circuits, your outdoor plug-in circuits, or swimming pools, that kind of thing. And notice a lot of and this is for all the board members here, a lot of your appliances like a hair dryer, they'll have it online on the cord. They'll have a GFCI there, so it has a place. But it was not looked at properly, when they passed this and they included this in the 2020 NEC. And the manufacturers are coming at it, and I don't think they want to make a change. And that's so if they don't make a change, that's going to throw another monkey wrench into this, how we go forward. But a key to this, and we also talked about this, it was also talked about in the electrical advisory board, if a air conditioner is installed properly and it's grounded properly, this is not a problem, and that fatality that happened wouldn't have happened. So you have that. And so the GFCI was just something added on top of that, right? So if a unit was installed improperly, had an improper ground, it would be safe. So this is an ongoing situation.
Bill, it's Jerry Bittner. I had a question. I think you kind of partially answered it. It sounds like a delay in adopting this completely until 2023 is predicated on the equipment manufacturers solving this problem and continuing the use of the GFCI. Am I understanding that correctly? That's the reason that it's only being delayed until 2023, and that the NEC is not being looked at to alter their code provisions with respect to this equipment in anticipation that all the equipment manufacturers are going to change and fix this so that it works with GFCI.
Well, that's precisely correct, Mr. Bittner. It is predicated on that, but we can only do what we can do. And I know that there are equipment manufacturers and others that are trying to work with the NEC in that code section and get it completely changed and completely taken out, and whether it does or not. And it is going to rest on the manufacturers to be able to actually take some quick action and change their specifications and, you know, come up with you know, there's manufacturing costs there too. If they were to change their design to limit the leakage of voltage to ground, you know, the threshold, then I'm sure there's, you know, fiscal note on that as well. So this is ongoing, but we did what we could right now, just so we could protect the public and the contractors can continue work. And so it is unfolding and it's ongoing, and I can't tell you how it's going to end up. But your question was right on point.
One other question, and it has to do with what's actually happening to the equipment. Am I to understand that the majority of these issues are nuisance trips, or are we seeing total component failure?
No, we're seeing trips.
VFDs, compressors, valves, things of that nature. Or I'm trying to understand whether the equipment's burning up and it's a huge financial burden to get these things replaced, or whether this is predominantly nuisance tripping.
No, that's a good question. And it is predominantly nuisance tripping. I haven't heard of any situation where it burned up a component or caused that. It's just the tripping. And, you know, just like the one contractor in Cypress, Texas, he could not get the equipment to stay online. And he just didn't have a solution for them. If he followed the code, they would basically be inoperable because they would not stay online. And it's mostly the inverter type compressors, but it can also happen on a standard reciprocating compressor as well.
Okay, thank you.
Mm-hmm.
All right, team, board members. So at this time, I'm going to ask for a motion and a second motion to approve the rule amendment as presented. So do I hear a motion?
I'll move.
Mr. Graves made a motion. Do I hear a second?
This is Jerry Bittner. I'll second the motion.
Mr. Bender made a second, and Ms. Delia, will you take a roll?
Yes, sir. Dolores Campion,
Yes.
Jerry Bittner,
Yes.
Suzanne Smith,
Yes.
David Morris,
Yes.
and James Graves.
Yes.
Motion passes.
Thank you. I didn't bypass the discussion because I figured we had it on the front end, so apologies there. So with that said, we get to move on to item H, a recommendation for agenda items for the next board meeting. Any recommendations at this time? Or
Mr. Campion, this is Doug Jennings. Just wanted to follow up. As I mentioned in my presentation, we will bring the comments back to the board, and you will have a second look where you can consider the comments and determine whether or not the the rule should be recommended as written, or if there should be modifications made to it. So that will be on the next agenda. Thanks.
Okay, that'll be on the next agenda. All right, meaning that, okay. Regular rule process. I know this was presented kind of interfered in the thought process here a little bit, but we're presenting as like this other piece never happened, and we're going strictly to the rule changing process. All right. So any other items in reference to item H? All right. So here's the, here's a good piece right here. Item I, discussion and date and time on the location for our next board meeting. I've looked at my calendar and I'm open any one of those days as long as we maintain a 10 o'clock open time, but we can table that and discuss that at a later date. But is there any conflicts at this time that y'all may see for the September meeting?
The dates for the September meeting?
7th, 9th, and 10th. Ms. Daddy, if you want to kind of.
Yes,
Yeah,
sir.
I think the 7th would work better for me.
Okay.
Ms. Delia, I think we'll follow the normal process where you'll kind of get back with us and kind of poll the audience and see what would be a good time frame.
Yes, sir. I can pull the
Date.
3 dates. Yes.
Okay.
And it'll be at 10 o'clock in the morning.
Okay. Thank you so much for that. And I think, sometimes this is the best part, but it's actually bittersweet because I don't get to see any of y'all anymore. Hopefully that will change in the very near future. My local stop to Buc-ee's and stopping by and picking up some sweets and things of that nature and bringing them. So at this time, I will announce adjournment of the meeting. And I don't even think I need a motion for that, do I? I've kind of gotten rusty at this. So adjourn the meeting. It is 12:12 on 6/30/2021. And I look forward to seeing everybody here in the very near future.
Okay. Thank you.
Everyone.